Minister to move second reading.
Mr. Deputy Speaker, I beg to move that the bill now be read a second time. So the first duty of government is to keep its citizens safe. The United Kingdom faces an enduring threat from terrorists, from hostile actors and from organised criminal groups, and that threat is evolving and becoming more sophisticated. It is not enough for us to keep pace with those who do us harm. We must endeavour to get and then stay ahead of them. The investigatory powers are the legal powers available to law enforcement, to the intelligence services, MI5, SIS and GCHQ and other public authorities, where appropriate, to obtain communications and data about communications. The Investigatory Powers Act of 2016 provides a clear legal framework for the use of these powers, combining world-leading safeguards and oversight with giving agencies the tools that they need to protect us. There is a double lock for the most sensitive IPA powers, meaning that an independent judicial commissioner must approve a decision by the Secretary of State to issue a warrant under the IPA. The use of any of these powers must be assessed as necessary and proportionate, with a strong independent oversight by the Investigatory Powers Commissioner. And the Investigatory Powers Tribunal provides a robust mechanism for providing redress in respect of any unlawful use of those powers. I will.
I'm grateful to the Home Secretary for giving way, because he will be as aware as I am that very, very occasionally those in charge of our intelligence and security services don't act in the best traditions of this country and with their offices. And I'm thinking of cases like Belhaj and Boudikhar. So where people have been the victim of mistreatment as a consequence of UK complicity with foreign powers, for example, should there not be a right for these people to have access to the information about that?
I listened carefully to the point the right honourable gentleman has made. I'm not sure it's directly relevant to the to this, but I will take on board the points that he made, and he'll forgive me if I don't address them directly just at this point. So I want to consider them properly. The IPA is sound legislation, but the nature of these threats has evolved since 2016, and we are confronted by greater global instability and technological advancements, and they demand that we act. Terrorists, child abusers, organised criminals and malign actors from hostile states have exploited technological advances, and our job is to ensure that the UK's investigatory powers framework remains fit for purpose. The changes that this bill proposes were informed by the independent review of the IPA published by the Noble Lord Anderson of Ipswich in June 2023. The bill received cross-party and cross-bench support as it passed through the other place. Every government amendment was accepted, and I want to thank the members of the Intelligence and Security Committee of Parliament for the productive way that they engaged with and helped to shape the bill. In particular, we have agreed to tighten the drafting of clauses 22 and 23 in line with amendments proposed by the Intelligence and Security Committee. These changes put beyond doubt that the Prime Minister can only delegate warrants for the purposes of obtaining communications of parliamentarians in two and only two exceptional circumstances: the personal incapacity of the Prime Minister, or if there is a lack of access to secure communications. There is also a limit of 5 Secretaries of State to whom this responsibility could be, in those circumstances, delegated. Further to this, in respect of the new Part 7A, parliamentary scrutiny will be enhanced through a statutory requirement for the Secretary of State annually to inform the Intelligence and Security Committee about the new regime for bulk personal data sets. And I will give them.
Sir John Hay. Grateful, my friend. He's mentioned the ISC scrutiny of these matters, and he will understand the concern about widening the number of people who can play the role that's previously been played exclusively by the Prime Minister. Has he considered possibly in doing so, and I can understand the reasons for that, by the way, limiting that to those Secretaries of State that have warranting powers?
We had looked at that. I think there is a balance to be struck, and actually the Secretary of State to whom this function could, in those two exceptional circumstances, be delegated, the bulk of whom do have warranting powers. I think the Secretary of State for Defence being the only one that does not. But so I think the point he's made is a fair one, but the scope of the bill is not much greater than the point that he put forward. I'll now turn to the. Of course I will. Of course I will.
As a member of the IEC, I welcome the government's accepting our recommendation on this, but I'd like to understand why the government aren't accepting our other proposal, which is a very simple one, is that when a delegation takes place, that the Prime Minister will be informed about that afterwards.
Yeah, I mean, I think it is inconceivable that the exercise of a delegated authority would not be the Prime Minister of the day would not be informed of the use of a delegated authority.
They wouldn't be informed about the delegation. It's the actual that the Prime Minister would then look at the case afterwards, not to second guess it, obviously, because it's already been agreed. But we were suggesting that, as a matter of course, the Prime Minister should afterwards then be informed of the actual contents of that warrant. And for some reason, the government's resisting that. And I can't understand why.
If my answer wasn't clear, I understood the point he was making, but I would suggest it was inconceivable the exercise of this power would not then be routinely informed to the Prime Minister. But ultimately, that is, that is a level of, granularity that adds complexity to the bill without necessarily utility. But, as I said, through the passage of the bill thus far, we have listened carefully to the suggestions that committee has put forward, and whilst if we don't always agree, I can reassure him and the other members of the committee and the members of the House that we will continue to act in a listening mode to the suggestions put forward by the committee. I will, but I do want to make some progress.
Thank him for giving way. He's mentioned listening to the scrutiny by the ISC. The Joint Committee on Human Rights, we've also issued a call for written evidence on the bill. And of course, as he knows from the Human Rights Memorandum, the bill raises important human rights issues relating to the right to privacy, freedom of expression, and possibly also the right to an effective remedy. So will he undertake to look closely at any correspondence the Joint Committee might send him when we've completed our scrutiny of the bill?
I can assure the Honourable and Learned Lady that we will do exactly that. We will do exactly that. Turning now to the measures in the bill, we are creating a new regime for bulk personal data sets that have low or no expectation of privacy. For example, certain data sets that are widely publicly or commercially available anyway. Bulk personal data sets are an essential tool to support our intelligence services in identifying fragments of intelligence within a large quantum of data, in order to disrupt the threats such as terrorism and hostile state actors. The bill seeks to create a new statutory oversight regime for how the intelligence services access and examine bulk personal data sets held by third parties. This places this oversight on a statutory footing, increasing the transparency of the regime. And the regime will be subject to strong safeguards, including the double lock. We're also making changes to the notices regime that will help the UK anticipate and address the risk to public safety of companies rolling out technology that precludes lawful access to data. We want to work with those companies to achieve common goals, but we must have the tools available when collaboration falls short. There are three types of... I will give them.
I know he wants to make progress, but I'm grateful for the opportunity to comment here. These reforms to the IPA are necessary to upgrade our world-class regime to ensure that our frameworks are kept up to date with evolving threats and, importantly, technology. And I want to jump on the point that he just referred to. We know that the terrorists, the serious organised criminals, the fraudsters and the online paedophiles all take advantage of the dark web and encrypted spaces to plan their terror, to carry out their fraudulent activity and to cause devastating harm to some innocent people, such as children, in the field of online paedophilia. Does my honourable friend share my concern and indeed frustration with certain companies like Meta and Apple, the former that has chosen to roll out end-to-end encryption without safeguards, the latter which has rolled out advanced data protection, which will allow these bad actors to go dark, which will severely disable the agencies and law enforcement from identifying them and taking action, and which will enable and indeed facilitate some of the worst atrocities that our brave men and women in law enforcement agencies deal with every day.
My right honourable friend and immediate predecessor makes incredibly important points. Digital technology, online technology has been a liberator in so many ways, but sadly, as is the case with technology throughout time, it has also been used by those that would do people harm, and indeed she mentions particularly the harm done to children. We take that incredibly seriously. We value the important role that investigatory powers have. We will continue to work with technology companies, both those well established at the moment and those of the future, to ensure that we maintain the balance between privacy and security, as we have always done, but ensure that these technology platforms do not provide a hiding place for terrorists, for serious criminals, and those people taking part in child sexual exploitation. The three types of notices under the existing IPA, the data retention notices, technical capacity notices, and national security notices. And these notices must be both necessary and proportionate, and of course are subject to the double lock. The bill does not introduce any new powers for acquisition of data. This is about making sure that the system is up to date and that it remains robust. The bill will create a notification notice allowing the Secretary of State to place specific companies under an obligation to inform him or her of proposed changes to their telecommunications services or systems that could have an impact on lawful access. This is not a blanket obligation and will be used only where necessary and only where proportionate, and only then on a case-by-case basis. The notice does not give the Secretary of State any powers to veto or intervene in the rollout of a product or services. It is intended to ensure that there is sufficient time for appropriate consideration of the operational impacts and potentially for discussions with the company in question about the proposed changes. The public rightly would want their representatives to know in advance if companies are proposing to do something that puts public safety at risk. And responsible companies will, of course, work with governments to avoid endangering people. Those people are, of course, also their customers. The bill also amends the IPA to require the company to ensure that existing lawful access is maintained. This means that the company cannot legally take any action that will negatively affect the level of lawful access for our operational partners during the review period. In the other place, the government tabled an amendment to allow for a timeline for a review of a notice to be specified in regulation. We also gave the Judicial Commissioner further powers for managing the review process. Taken together, these ensure companies are clear on the length of time that a review can take, which reduces uncertainty for their business, as well as providing greater clarity for the process of review. My noble colleague, Lord Sharp of Epsom, in the other place, also committed to a full public consultation before amending the existing regulations relating to the review of notices and laying new regulations relating to the notification notices. The bill also clarifies the definition of a telecommunications operator to make clear that companies with complex corporate structures that provide or control telecommunications services and systems in the UK fall within the remit of the IPA. These changes do not directly relate to any particular technology, including end-to-end encryption, but they are designed to ensure that companies are not able to unilaterally make design changes which compromise exceptional lawful access. The bill makes changes to the powers of public authorities to acquire communications data. Section 11 of the IPA made it an offence for a relevant person within a relevant public authority to knowingly or recklessly obtain communications data from a telecoms operator or a postal operator without lawful authority. The bill will set out examples of the acquisition routes that amount to lawful authority outside of the IPA, giving greater clarity to public authorities that they are not committing inadvertently an offence. Further targeted amendments will ensure that public sector organisations are not unintentionally prevented or discouraged from sharing data. And further changes will allow bodies with regulatory functions to acquire communications data. The bill also creates a new condition for the use of Internet Connection Records, ICRs, by the Intelligence Services and the National Crime Agency. The IPA currently requires certain thresholds to be met on the known element of an investigation, such as exactly when a website has been accessed. This limits the ability of operational partners to use the ICRs to detect previously unknown criminals, terrorists, or state threat actors who are acting online. The proposed measure will allow greater detection of high-impact offenders by removing the requirement to unequivocally know a specific time or times of access and service in use, and instead allow these factors to be specified within the application. Or, please.
Captain Jones. Yeah, I mean, I understand the use of this to the security services, but it also broadens the scope of how many people could drag into this measure, and there is no judicial oversight in terms of before the security service or whoever's using this, and also it talks about in the bill that it's for national security and economic well-being, and I've got to say, I think this is a catch-all for quite a lot of things. And I think although the intent is right, I think there needs to be at least some safeguards that innocent people are not being dragged into this quite broad, potentially broad measure.
I understand the point the honourable gentleman makes. I mean, within data set capture, innocent people's data is often acquired and is always deleted. And with regard to the economic well-being, that merely reflects the language that's used in other parts of this for consistency across the various strands of the work that we do.
I thought we were here today to actually scrutinise this bill, not think it was a chore on behalf of the Home Secretary to have been asked questions. But the definition in terms of well-being could be quite broad. I understand, I think he does, and the House would, national security. This well-being could put quite a broad definition, and I'm not yet convinced that I've yet seen what that is. If it's just that it's a bit of consistency in this legislation to another piece of legislation, I'm not sure that's a great argument for actually including it in this piece of legislation.
I disagree with him. Is the simple truth of the matter. I think with legislation of this nature, and particularly with regard to clarity of intent, maintaining consistency of language with previous relevant pieces of legislation, including the 94 Intelligence Services Act, for example, I think is incredibly important. But as I say, I recognise that he has given thought to this, and we don't disregard the points he's made, but we have thought through the importance of consistency of language, which is why we maintain the consistency of language. Please.
Thank you for giving way on that point. I think that a general listener to our proceedings might worry that the new powers might be used for fishing expeditions rather than the very specific powers that they replace. So could he give them some words of reassurance from the dispatch box that that broadening of bulk data collection without the specific dates isn't going to be used for fishing expeditions, which might affect the privacy of ordinary citizens who've done nothing wrong?
I mean, the Right Honourable Lady makes, I think, an important point, but it's a point that could be applied to any bulk data set collection of which she knows there are many across government. And there are provisions in place to ensure that the data of innocent people are not held, that the data are deleted, and that our security services and the other organisations that will utilise these powers always do so carefully and cautiously. And of course, there are safeguards in place that I've made reference to with regards to the Investigatory Powers Commissioner and the Tribunal if there is wrongdoing. So there are safeguards in place, and they are relevant. The proposals are put forward for a very specific reason, and we've given thought to kind of mission creep and broader expansion, and the government feels that this is a modest extension that will actually give significantly greater protection to the British people.
I mean, one of the things that I think, if what my honourable friend has just said, we need to give confidence to the public that what we're actually doing quite rightly to protect our security has that level of security in it. And on internet connection records, there is no judicial oversight of that process. So isn't it the fact that if we are going to give these powers to the security service, which I approve of, that to ensure that we can say to the public that these are proportionate, and also that there is an independent process into ensuring that these can't be abused, surely judicial oversight throughout this should be an important thing.
I mean, I noticed he's quite specific saying about judicial oversight, but the point is there is oversight. There is oversight. There's oversight by the Secretary of State through the warrantry process. There's oversight of the whole process by the Investigatory Powers Commissioner. There is oversight of the Secretary of State function through the committee on which he sits. So there is oversight.
I agree, and that's why I support that oversight, even though I've got to say this government doesn't make our job very easy on the ISC. But on the internet connection records, there is no, as I'm reading the bill, unless I'm missing something, there is no judicial oversight of that process. And that's what I'm saying, is if we actually want to give people confidence, having that backshop of judicial oversight should be the important thing.
No, as I said, I noticed he was specific in saying there is no judicial oversight. The point I'm saying is I'm not disagreeing with him. The point I'm saying is there is oversight. There's more than one, and indeed the committee on which he sits is part of that oversight process. I will give way on that.
Grateful. Lynnie has just touched on the importance of the oversight role of the ISA, particularly in relation to these additional provisions. I just wonder if he remembers the passing of the National Security Bill. We're actually in the final stages of that important piece of legislation. The government tabled an amendment in lieu, promising that it would progress a review of the Memorandum of Understanding within 6 months of the National Security Bill coming into force to make sure that there was an updated and robust relationship between the government, the Prime Minister in particular, having been unable to secure a meeting between the ISA and the Prime Minister since 2014. Remarkably, I just wondered, given the nature of the ISC's important role in these provisions, if you could give us an update on where that review has got to.
That's not an element of this bill. I can. So no, in terms of the commitment for the Prime Minister meeting with the committee, I'll look at the details with this. But I will make progress, because I want to make sure that everyone who wishes to speak in this debate is able to do so. But I will give way to the right under it.
Just on that point, will the Home Secretary encourage the Prime Minister to go before the Intelligence and Security Committee at the soonest opportunity? Because my understanding is it hasn't happened for 10 years.
Well, I can't commit the Prime Minister to... I can't make a commitment on his behalf. Members of the committee will know that certainly in my previous role, I appeared before the committee. I think it's important that government does make itself available for this. As I say, it would be inappropriate for me to demand of the Prime Minister attendance anywhere, but I will absolutely pass on the Right Honourable Lady's point.
Just to assist the Home Secretary with a little context, when I was previously a ranking member of the Intelligence and Security Committee between 2010 and 2015, it was a matter of routine that once a year the committee went to see the Prime Minister, usually in the Cabinet room. This stopped in 2014, and successive Prime Ministers have failed to reinstate it, although it must be said that the shortest lived of them did offer to meet with the committee, but sadly ceased to be Prime Minister before that became possible.
The lengths that some people go to avoid committee scrutiny. I'm trying to remember where I was. It's been such a long time since I looked down the page of this speech. Where are we? Proposed measures will allow greater detection of high-impact offenders by removing the requirements on... I've done that. All such applications must be necessary and proportionate and subject to independent authorisation or independent inspection. The bill will also strengthen safeguards for journalistic material within the Investigatory Powers Act bulk equipment interference regime, aligning it to changes to the bulk interception regime which are underway to ensure compliance with obligations under the Human Rights Act 1998. Prior judicial authorisation will be needed before material obtained through bulk equipment interference can be selected for examination using criteria where the purpose is to identify or is highly likely to identify confidential journalistic material or confirm a source of journalistic material. Prior judicial approval is also necessary before such material may be retained for the purposes other than its destruction. The other measures in Part 5 of the bill will ensure that the resilience and protection of the regime are maintained and enhanced. The bill also makes improvements that will support the Investigatory Powers Commissioner in effectively carrying out their role, ensuring that the world-leading oversight regime remains resilient. This includes powers to enable the IPC to appoint deputies, delegate some of their functions to judicial commissioners and the newly created deputies, and put certain functions on a statutory basis. The bill will ensure there is a clearer statutory basis for reporting errors to the IPC. Mr. Deputy Speaker, this bill brings the Investigatory Powers Act up to date.
I'm grateful to him, a sense that he's coming to the end of his speech, and I just want to raise another important group, because we've mentioned parliamentarians and journalists. I want to talk about trade unions, because some people fear that this bill will open the door even further than its parent bill on the surveillance of trade unions. And I wonder whether he will agree with me that there should be no place for the surveillance of trade unions in a democracy. And if he agrees with that, will he consider amendments to the bill to make sure it doesn't happen, including a redraft of Clause 5?
I will take the point that the Honourable Lady puts forward. I think there are a number of organisations that are not explicitly mentioned in the bill where that argument could be made, and I'm not sure it would be necessarily useful or right to list them all. But I will take on board, and genuinely in good faith, the points that she makes. The bill brings the Investigatory Powers Act up to date with the modern age, provides greater clarity, makes the system more resilient, and retains the world-leading safeguards of civil liberties and commercial integrity. And above all, it will mean that the men and women who work often without recognition, but who work so incredibly hard to keep us safe, have the tools that they need to do so in the modern era. And I therefore, Mr Deputy Speaker, commend this bill to the House.
Yeah. Question is that the bill be now read a second time. Opposition front bench, Yvette Cooper.
Thank you, Mr Deputy Speaker. The